Good morning. Happy Thursday. Somebody somewhere hit a power pole, and the entire town that I work in has no power. So I'm sitting in the parking lot watching traffic get backed up. All very fun. Figured, what the hell? Might as well make a video. I've been getting a lot, I guess. I've been getting some comments back on older blind justice videos where I cover his arrest. And most of the responses are, "Nuh-uh, you're wrong," and that's about it. No one has yet presented any cases or statutes or anything refuting what I'm saying other than, "Nuh-uh, you're wrong." But let me see if I can't go over it a little bit more to maybe help some of you who don't understand what's going on. The first concept that you really have to grasp is reasonable suspicion. Reasonable suspicion is a very low burden of proof on the officer. You got to remember, the seminal case for reasonable suspicion is Officer McFadden saw a guy walk up to a window of a shop, walk back to a corner, and talk to another dude. Walk up to the window, walk back to the corner, talk to a dude. Walk up to the window, look in, walk back to the corner, talk to the dude. Then they go down the street and meet up with another dude. You're thinking, where's the crime, right? Well, Officer McFadden determined that there was reasonable suspicion crime was afoot, and he was able to articulate that reasonable suspicion to the court in such a way that the court agreed with him. He thought that these guys were planning an armed robbery. He called it a stick-up job. But an armed robbery is, you go in, you point a gun at the clerk, you take the stuff you want, including the money that you want, and you run out. And lo and behold, he ended up frisking one of these guys because he had reasonable suspicion that they were either committing or about to commit or had just committed a armed robbery, that they would therefore be armed. And so he patted them down and he found a firearm on one of them. So that shows you how low that burden of proof is in order to get reasonable suspicion. Another example, a gentleman is standing at the corner of a building with an opaque bag. That's a bag you can't see through. Like a black plastic bag, maybe a paper bag, but probably a black plastic bag or some sort of bag you can't see what the contents are. A group of officers know the area is a haven for people selling drugs, and so they roll in a convoy. The gentleman standing on the street corner, this is Illinois v. Wardlow, for those of you who want to look it up, sees this convoy of cops rolling in and takes off running. Well, the combination of facts that the officers are able to articulate is that it's a high crime neighborhood known for drug offenses. People tend to have guns on them to protect their drug turf. And the guy saw the cops and ran. Those are the facts that they could articulate. They don't have to say what crime they suspect him of committing. They just have to say Officer McFadden could articulate the specific crime, but all they have to do is have reasonable suspicion that crime is afoot. That there is some sort of criminal activity that either has happened, is happening, or is about to happen. That's all they have to have in order to begin the reasonable suspicion stop, the Terry stop, and maybe go on to the Terry frisk if they also have reasonable suspicion that the person is armed, unlawfully armed and about to commit a crime. So it's a very low standard of proof. In Illinois v. Wardlow, the guy took off running. The cops chased him. They ended up catching him. Inside the bag was a revolver. Obviously, it was an unlawful weapon, and so the guy was facing a weapons charge. And he tried to suppress the evidence, saying that the cops didn't have reasonable suspicion. But it is such a low standard of proof that it's very difficult for the cops to not have reasonable suspicion for a stop. It is very difficult. I saw the guy weave a little bit in the traffic. Did he leave the lane? No, he didn't. He never left his lane, but he weaved a little bit. And I thought he might have been drinking, or he might have been under the influence. And next thing you know, the cop has reasonable suspicion. Okay. Anyway, text from the office. Still no power. Lovely. So the reasonable suspicion standard is incredibly low. So what was happening when Blind Justice and his wife were encountered in the church parking lot? I agree with everybody to say it's a church parking lot. Sure, it is private property. I don't know if there were no trespassing signs posted, and I don't care. However, what the officer saw was a vehicle in the parking lot, probably rolling slowly, because people who play Pokemon Go and like to cheat, like, I don't know, people who are blind and get handicap parking tags for their vehicle so that they could park up closer to the building, you know, like it's their legs that are broken and not their eyes. I mean, come on, dude. But anyway, people who like to cheat, I know this because my sister-in-law does it all the time. They roll slow. They roll slow so it pretends that they're walking. Their phone thinks that they're walking because they're moving slow enough. And I'm sure the cop saw them rolling slow through there. And they're in a very dark place where there's no reason for them to be. And they start acting squirrely as soon as he gets up to the window. These are all things that the officer can articulate. And I know the officer can articulate them because I can articulate them. And that's what the officer was saying. Like, you're back here behind the church. There's no reason for you to be back here behind the church. You're acting weird. There's no reason for you to act weird. You're not giving me your ID. There's no reason for you to do it. He has a right to ask you because he has a right to ask the wife, specifically Blind Justice's wife, because Blind Justice's wife was operating a vehicle. And you're going to say, well, maybe the vehicle was stopped. Well, we don't know whether it was stopped or not, but I have a sneaking suspicion that it was slow rolling. But even if it wasn't, she got there somehow, and she's behind the wheel now, and the keys are there, and so she's going to operate it. I mean, he could do a stop. He might think she's drunk. He might think she's high. What else are you going to do back behind a church? Now, you're going to say, well, there are also legal things you could do back behind a church at some ungodly hour of the morning. And you're correct. But you don't look at what the possible legal rationale is. You look at the possible illegal. And we have power. Sweet. So I'm going to wrap this up. You look at the possible illegal activities. So when the guys in Terry v. Ohio, when Terry was walking up to the window and looking in, well, I mean, there's a perfectly legal explanation for that. You know, maybe he's window shopping. Maybe he's thinking about a gift he wants to buy his wife. There are perfectly valid thoughts that you could have about what he's doing that would be legal. The problem is there are also valid reasons why he may be doing things that are illegal. There is still reasonable suspicion that crime is afoot. You don't have to have 100% surety that there is crime afoot, that a crime is being committed. That is a different standard of proof. That's beyond a reasonable doubt. That's something that the police and the prosecutor are going to have to prove in court at trial. But in order to start a stop, in order just to stop you for a short period of time to do an investigation, all that requires is reasonable suspicion. It doesn't mean that you're guilty. It just means that the cop has seen things that combined with his intuition and experience, he's seen facts that when he combines those with his intuition and experience, allow him to stop you legally, and if you're operating a vehicle, to demand your ID. Now, he had a right to demand the wife's ID because she was in operation of a vehicle. May not have had a right to demand Blind Justice's ID. I don't believe that North Carolina is a stop and ID state. Although it depends on whatever their ID statute is. They will have some sort of an ID requirement, a requirement to show ID to an officer if you've been stopped operating a vehicle. They just do. Every state does, and I'd have to read it to determine whether they could have demanded his. But I am 100% certain that they could demand hers, right? So she had an obligation to ID. Now, what was going on in the vehicle is that Blind Justice was in there talking to her, telling her not to comply with the cops. And he was interjecting between the cops. Now, the cops were also asking him for his ID, but that's not relevant. The relevant stuff for the statute that he was charged under, the only relevant information is that the cop had a right to her ID. He had a right to conduct his investigation of her with getting that ID because she was operating the vehicle. That is the relevant fact that you need to be aware of. And so Blind Justice interjecting himself into that, just like the defendant in State v. Lay, which I referenced in the other video, where he was interjecting himself into the officer's investigation, and the officer was trying to conduct an investigation and get the guy to shut up so that he could do his job, and the guy wouldn't shut up. Just like in that case, Blind Justice was interjecting himself into that interaction between the cop and Blind Justice's wife. Now, I understand you're going to say, well, it's his wife, he has the right to do it, this and that, and the other thing, except he doesn't. Because if the officer has the authority to conduct an investigation. If he's made a legal stop with reasonable suspicion, he has the right, he has the power, he has the authority, he has the ability to conduct an investigation. And if you interfere in that investigation in North Carolina, you may be charged with resisting an officer. Blind Justice interfered. He was charged with resisting an officer. That's the long and the short of it. Nothing else really matters. It doesn't matter what the cop says to Blind Justice. It doesn't matter what the cop tells you his rationale was for the initial stop. None of that matters. You're going to get the defense attorney might try to get the cop on the stand and say, hey, did you say this? And then the cop might say, yeah, but guess what, kids? Cops can lie. As long as they're not under oath, there is absolutely no ramification for a cop lying. A cop can lie to you as part of his investigation. Cops often lie. It is part and parcel of being a cop is to lie to suspects. So you're going to get a very nonplussed judge being like, well, congratulations. You just proved that a cop during an investigation lied to a suspect. Congratulations. What do you want, a cookie? No shit, they lied to a... No shit, the cop lied to the suspect. This happens every time, all the time. There is no difference from this case to any other case. The cop does not have an obligation to tell the suspect the truth. The cop does not have an obligation to tell the suspect what his reasonable articulable suspicion of a crime is. The cop does not have to articulate to the suspect a goddamn thing. But the suspect, because of the statute, or the passenger in the car, or onlookers, because of the statute, have an affirmative duty to not interfere, to not resist with to resist an officer in the course of his investigation. Because that's what the statute says. And unless you could find some statute or some case law for me saying that the cop has some affirmative duty to not lie to a suspect, or has the duty to actually articulate to the suspect his reasonable articulable suspicion, then you've got no argument. Speaking of no arguments, I did see a letter, a motion on binder paper filed by Chauncey. Chauncey Hollingberry, also known as Dragonfire Auditing, I think it used to be. He was the guy who did a seance with Beelzebub to figure out how big my penis was and whether or not I cheated on my taxes. So he's that fella. Anyway, I think he's in prison right now, awaiting trial. Maybe he's in a jail, but I think he's in a prison. Either way, he's being held for trial. He's not out on bail. And at some point in time, the court decided to assign him an attorney. Think of it like a public defender, except this is a private attorney. This is an attorney in private practice who's part of a program where he will take, basically he will allow the federal government to pay him to represent indigent clients who can't afford to pay an attorney themselves. So he is functionally the same thing as a public defender, except he's in private practice. He was he was assigned back in August, I think, and already Chauncey's filing a motion to get rid of him. The very first page of Chauncey's motion was fine. Chauncey said that the attorney hadn't talked to him in a month and wasn't returning his phone calls or anything like that. And that is a perfectly valid reason to get rid of an attorney. But then on the second page, Chauncey continues his motion with a bunch of irrelevant information like, oh, the prosecutor is pursuing baseless charges and introducing evidence that is, whatever. He goes on about other things that aren't related to his relationship with his attorney. And that just kind of solidifies the fact that the court is going to make him keep an attorney. But Chauncey did file a motion to change attorneys. Maybe Chauncey's hoping to not have an attorney at the end of it, but with the sovereign citizen style arguments that Chauncey likes to make, I'm sure that the court is going to have little to no tolerance of it and will most likely assign him a new attorney if they do assign him an attorney. And I suspect that they will assign him a new attorney. It's pretty easy. Generally, you'll get one that the court will almost automatically grant, and then if it becomes a habit, then the court might change its mind and make it a little more difficult to get a new attorney. One other thing of note that I find hilarious, because I am an attorney, because I have to deal with clerks, we call it the tyranny of the clerks. On Chauncey's motion, which he submitted from jail. I mean, he doesn't have access to a printer, I'm assuming. He doesn't have access to the law library because he is represented right now, I'm assuming. I don't know exactly the rules in that particular jail. But he had to write his motion, handwrite it on binder paper, just regular college ruled kind of binder paper. And the clerk stamped on it, this may be rejected because it doesn't comply with local rules of civil procedure 5.4. Now, I really don't much care for clerks anymore. I used to try to be nice about it, but now everything is file by mail or file by Dropbox or e-file, and clerks are just, they're not the happy customer servicey kinds of people that they used to be. And they like to practice law. But anyway, I checked out the local rules of criminal procedure because, again, Chauncey is facing criminal charges, and the only local rules of civil procedure that the local rules of criminal procedure for the Arizona District Court that it has adopted are local rules of civil procedure 7.1 and 7.2, which deal with the format of the motions. And Chauncey did comply with those. Local rule of civil procedure 5.4 is something about it having to be legible copies for the judge or something along those lines, which he obviously could not comply with because he is stuck with binder paper and handwriting. But luckily, I don't like Chauncey, but I certainly don't want him to have his rights denied by some tyrannical clerk who thinks they know better than Chauncey does, and tries to get his little motion rejected on a technicality. So I'm glad it got filed. I'm glad the judge has seen it, and I believe there is a hearing set for October 30th, roughly, on that. So, it's not a real big deal. I probably won't even remember about it, but Chauncey might be getting himself a new attorney. So good for Chauncey. Anyway, that's about it. I'm going to head into work now since apparently we have power. Thanks for watching. Have a great day.